Good morning, friends. We welcome you to the Legal Breeze, which gives you a complete update on the legal education and current affairs. In today's program, we will be discussing about the Forest Rights Act 2006. What is the importance of this act? What is the objectives of this act? Whether the objectives enshrined in the Forest Rights Act have been achieved? What is the gap between the theory and practice? What is the reasons for its non-implementation of this act? What is the approach of the judiciary in the process of implementing this act? All these things will be studied in this particular edition is concerned. And before I go into the subject, if you have not subscribed the channel, please do subscribe and post your comments in the comment section. That will motivate our students who are assisting me in the process of imparting knowledge or disseminating knowledge across the society. Let it be a contribution from your side. Thank you all. Now we will come back. The Forest Rights Act 2006 has come into little with the back date, that is 13th December 2005. That's the cutoff date fixed in the act itself. It has a preamble. It's a very short act, of course. The preamble portion of the Forest Rights Act is noteworthy. For the first time, the legislature, the Parliament of India, expressed its regrets on record that the injustice meted out by the tribes and other forest dwellers has not been redressed for a quite long time, right from British India till this date. That's a very welcomable part from the point of the legislature, because it is one of the important constitutional mandate to do social justice to the tribes and other forest dwellers. Until now, they have not obtained their share of justice, or their contribution to the economic growth has not been recognized, unfortunately. But this legislation makes a pledge to undo that evils. This is a very important one. How it is going to do that? That's a question. That also you can find answer in the very preamble itself. In the opening para, it says that the government wants to vest the land rights upon the tribes and other forest dwellers. How? By establishing necessary mechanism for claiming and ascertaining the rights, including the land rights, and vesting the title upon the tribes and forest dwellers, making them the owners and custodian of forest resources. For the first time, it recognizes that the tribes and other forest dwellers are forming integral part of forest and forest-based biodiversity. This is an important remark. We all should welcome it. And it also talks about the effective participation of the tribes and other forest dwellers in managing the forest resources, biodiversity, and other ecosystem forming part of the forest regime. Now let us go into this act. This act has certain definitions under section 2, ranges from section 2A to 2P, which we will discuss a little later. Section 3 enumerates various rights to be vested and to be enjoyed by the scheduled tribes who are dwelling in the forest and other forest dwellers. Section 4 lays down certain procedure, because whenever there is a rule, there is an exception. In certain areas, the forest rights cannot be given to the tribes and forest dwellers. This is called critical inviolate area. To put it differently, the areas in and around certain important critical wildlife sanctuary can be declared as critical inviolate. But what is the process for declaring it? Who can declare it? And what is the representation whether the opinion of the tribes are recognized in that, all these things are dealt under Section 4. It also deals with the inheritance of the rights by succession, all these things. Then Section 5 deals with the duties, because it is very important. Every right has a corresponding duty. So Section 3 vests or confers the rights upon the forest dwellers and other scheduled tribes forest dwellers. Section 5 lays down or imposes certain duties upon the aforestated persons. Sections 6 and 7 lays down the mechanism for claiming and ascertaining the forest rights. 8 is dealing with accountability on the part of the forest officials and other officials in performance of their duties. Thereafter, it is miscellaneous, such as rule-making power, protection of action taken by the public servant in good faith, all these things. For the first time, there is an accountability fixed on the part of the officials for their non-performance. If it is established that the officials didn't perform their duties in accordance with the statute, a penalty can be imposed, maximum of rupees 1,000 upon them, and the departmental action and including disciplinary action can be initiated against them. This is an important guarantee given in the Act. To what extent it has been implemented, that I do not know, honestly. Now let's come back to definitions. As I have already pointed out, Section 2A to 2P or 2Q deals with various definitions. Out of which this is very important: common forest resources, forest land, and there are certain things called critical wildlife, habitat, and the last habitat, then Grama Sabha, village, forest village. All these things are very important. Besides which, there is another important term called minor forest produce. This is also very important one. Certainly I will address about the minor forest produce issues and related issues in a separate video little later when the time comes. For the time being, you remember the rights can be classified into two: common rights, individual rights. Again, tangible rights, intangible rights. Okay, then the property rights. This is also there. Common rights are given to all. Okay, what are the community included? Because this is very important. There are two important terminology used: forest dwelling scheduled tribes and other forest dwellers. Besides which, it also uses certain terms called pre-agricultural community, PAC, and PTG, particular tribal groups, pastoralist, nomadist. All these terminologies have also been used interchangeably. And for scheduled tribes there is no problem, but for other forest dwellers there is a condition: at least they should have resided 3 generations in the forest or adjoining areas of forest for their bona fide livelihood. Okay, the bona fide livelihood of the aforesaid person should be depending upon the forest or forest based resources. This is applicable even to the tribes. But this 3 generations condition is not applicable to the tribes. Okay, and what is the cutoff date, which I have told you? 13th December 2005. So 13th December 2005 is the cutoff date. Any person resided prior to 13th December 2005, and he should have resided at least by 3 generations, at least for 75 years. This has been given in the rules, and it is in the form of explanation, because 1 generation is equivalent to 25 years. That's what the Act says. Okay, you have seen who are all the beneficiaries. Beneficiaries are STs, forest dwellers, and other communities which we have discussed. Now, what are all the rights which I have told you? Common rights, individual rights, tangible and intangible rights. So it talks about right to intellectual property. It's very, very rarity. But it can be community IPR or individual IPR. Right to traditional knowledge, right to access to biodiversity, right to use all the common land resources, including water bodies, ponds, fish, right to collect and dispose the minor forest produce. Like that, there is a great list given in section 3. Please go through that. And it also talks about all other rights enjoyed by them under various state laws. It's also can be included under this Forest Rights Act. Okay, this is very important. If any other state is giving greater rights, certainly it is welcomeable. But minimum standards are fixed by this act. So no state can provide rights which is stipulated lesser than the standards prescribed under this particular act is concerned. Then another important rights is that right not to be disturbed. This is a very important act because frequently these people are evicted in the name of developmental activities, construction of dams, all these things. It says very rarely these people can be evicted, only in certain conditions. Conditions are laid down under section 4. But even then, they have to be given an alternate assurance. First, you should create the alternate facilities. You should get the prior informed consent of the Grama Sabha in which these people are going to be relocated, and should have got approval of the Grama Sabha for making this livelihood, all these things. Only after ensuring all these things, only these people can be evicted. But once evicted, they cannot be re-evicted. That right has been guaranteed by this statute. This is a very, very important one. Now let us come back to this section 4, which talks about conditions in critical inviolate area, all these things. How to determine? There is a committee which is to be constituted, and the state government is the nodal agency to carry out all this process. The committee should give representation to the local experts, including the tribes. This is very important. This is very important. And if they say yes, there is no other alternative, including peaceful coexistence is not possible, then only the persons occupying that area can be evicted. And they have to be given a decent alternate location, decent livelihood, ensuring the dignity and the employment opportunities of the tribes. Then we have section 5, which talks about duties, like these persons should take care of biodiversity, take care of water bodies. To put it differently, they cannot adversely impact the biodiversity, flora and fauna. They shall not destroy the cultural properties, heritage, all these things. There is a duty vested upon them. Okay? And Grama Sabha has been given prominent role in all these aspects. Then how to establish the claim? It starts from the Forest Rights Committee attached to the Grama Sabha. It goes up to state level monitoring committee. Finally, there is a nodal agency, and that is the Ministry of Tribal Affairs, Government of India. So any person can approach the Grama Sabha for establishing his rights. The Grama Sabha, there is a committee called Forest Rights Committee, and the Forest Rights Committee's proceedings should be approved by Grama Sabha. And if he has any problem with the Grama Sabha resolution, he can approach the subdivisional level committee, and subdivisional level committee can settle it. That is one time appeal. But even if he has any adverse or he has any grievances against the subdivisional level committee, he can approach the district level committee. But the decisions taken by the district level committee is final. There is a state level monitoring committee which should supposed to monitor the implementation of this act throughout the state, at the district level, subdivisional level and village level. And they have to send a report to the ministry, that is the nodal agency, tribal affairs. So this is the structure given under this act. And we have already told you there is a punishment for the erring officials who do not exercise their duties properly. Though a beautiful mechanism has been granted under this act, still this act has not been implemented both in letter and spirit. Recently, the Supreme Court has issued all the states asking explanation why they have not carried out this particular act is concerned. Okay, I think it should be Vikramath versus Union of India. That's what I hope. Please check out the case. But the landmark case associated with this particular case act is concerned, there is a case called Vedanta case. Odisha Mining Corporation versus Union of India and others, 2014 judgment. It's a very classic judgment. It has given the important ruling that the tribal rights, the religious faith of the tribes can be equated to the freedom of religion guaranteed under 25 to 28. In fact, it says it is beyond that. So that sentiment ought to be respected. And they say prior informed consent of the Grama Sabha is very, very important. And without obtaining the consent, if you do anything, which is void ab initio. So they have referred the entire matter back to the Grama Sabha, and Grama Sabha meeting ought to be arranged by the district judge. He should ensure that the Grama Sabha meeting is done in an independent environment without affecting everybody's right. So it shows the Supreme Court commitment to uphold the values of this legislation, the constitutional entitlements of the tribes and other forest dwellers. I hope when the custodians of the forest rights are duly empowered, it will not only promote the forest-based biodiversity, but it will have a greater value in promoting the entire environmental growth as well as economic growth, so as to promote inclusive and sustainable growth. God bless you all. Thank you.